So, as rival politicians and their parties pursue their legal challenges against the presidential election in court, could Nigeria's disputed 2023 ballot be the political turning point in this country? Well, it depends on what happens, doesn't it? It remains to be seen what conclusions the tribunal will draw. It has several months to deliver its verdict, bearing in mind that litigating an election dispute can be a complex and enormously technical affair. So, as political attention shifts to the technicalities and the legalese of the court system, and the assessments from a legal standpoint start to pour in thick and fast, what hope is there for either side? Who will control the powerful legal algorithms, as it were, that will shape the outcome of these divisive and divided legal challenges? What will be the great common divisor that will tip the balance one way or the other? Well, for his much prized assessment, I'm joined now in the studio by the respected constitutional lawyer, human rights activist, and senior advocate of Nigeria, Femi Falana. Very, very honored and delighted to have you.
Thank you very much,
to see you. And as you continue to assess the outcomes of the presidential election, are you still questioning why the technology happened to fail only with the presidential election and not the National Assembly ballot, both of which were held on the same day? I'm wondering what questions and issues that raises for you.
Well, frankly speaking, I was flabbergasted, like many concerned Nigerians. But going by some of the reasons adduced by government sources, and I'm not sure whether INEC has put some of those positions forward. I think one of the ministries has stated, or rather a minister, that there was a lot of hacking of the server. So I'm sure when we get to the bridge, it will be crossed. If such an argument is put forward, again, it's going to be tested at the tribunal. So that's what I can say for now.
Yeah, I totally understand your reservations there. Yeah, I understand that. But you are, of course, a well-respected senior advocate of Nigeria in a country where a petition or legal challenge has never led to a presidential election result being overturned. Given the weight of evidence that needs to be submitted to satisfy the court, do you believe that the way things are today in this country, a presidential election can ever be overturned?
Charles, a lot depends on the evidence produced by the petitioners. But I'm not in any way pessimistic having regards to our history with regards to election petitions. I can tell you that for me, it's extremely disturbing, and I've made the point repeatedly. We cannot continue to involve the judiciary in the election of the representatives of our people. We must put an end to it. And we have thought that with enough reforms of the electoral system, that by now we should be taking the courts out of the electoral system. I'm disturbed as a lawyer that Nigerians are now saying the elections have moved to the courts. That's not very complimentary. But as I did say, elsewhere, Nigeria has the highest number of pre-election cases in the world and the highest number of election petitions. It should be a matter of concern to all genuine forces of democracy and all stakeholders, whereas the Yar'Adua government in 2007 set up the Justice Owais Electoral Reform Panel to look at this problem, because the winner of the election did say publicly that the election that produced me was highly flawed, and therefore I'm going to put an end to this ugly development. And so the panel came up with profound recommendations on total independence of the INEC, conclusion of election petitions before the inauguration of a new government, the setting up of an electoral offences commission to deal with electoral offences and malfeasance, so that attorneys general will not terminate those cases by filing applications of non-liable prosecution. But what has happened is that successive governments have just ignored those fundamental recommendations. And that's why we are where we are. So, but I think a situation where we had about 1,800 pre-election cases, about 600 appeals in the Court of Appeal, about 120 appeals in the Supreme Court. It's not okay. It's not good for
it. It sounds quite unhealthy,
of course.
Really.
And now,
yeah, you've got a big one coming in.
Election petitions all over the place. In a way that all major cases, including cases that pertain to the liberty of those who are languishing in custody, will have to give way to election petitions, because they are time bound. They must be decided within 6 months. And if you have to go to the Supreme Court in the case of governorship election, additional 2 months. So it's not the best for the country.
But I guess on the positive side, I mean, if you're a lawyer or a senior advocate of Nigeria, you'll be smiling all the way to the bank, won't you? I mean, this is the period.
No, Charles, I stopped filing election petitions since 2015.
I'm not talking about you in particular.
Yeah, no, my colleagues are certainly smiling to the bank. But again, at the end of the day, it's not enough to simply smile to the banks. We're all challenged.
Yes, there's a more profound thing to be focused on there. But I mean, given the thesis you just put out at the moment, which is a very interesting and comprehensive one, I mean, now that we are where we are, in spite of the Owais committee and all the rest of it, do you or don't you see this particular election, presidential election petition or petitions becoming a sort of locus classicus, as it's called in your legal circles, a first-time precedent-setting case?
No, we have had cases of this nature.
Yeah, but it's never quite got. I mean, it's never been decided in favor of someone who's making an application against the result.
Yes, you know. Yeah. But again, I go back to the 2007 presidential election.
Well, it came close, but it didn't do it, did it?
It was a 4-3 justices of the Supreme Court. So it's a split judgment. It could have been either way.
Yeah.
So again, as I said earlier, it depends on the evidence produced. In a couple of African countries, presidential elections have been allowed by the court. In Nigeria, a number of election petitions in the states have succeeded,
right,
in which sitting governors have been removed. So there shouldn't be any cause for
So from your perspective, it's entirely focused on the weight of evidence
for sure.
that is submitted.
For sure.
And you feel confident or not confident that justice will be delivered in the courts in that context? That there isn't a political element to it?
For me, because I go to the court every day.
Right.
Even though the courts in any capitalist society are not neutral with respect to the political development of
well certainly the Supreme Court in most countries is not neutral, including the United States.
It's a political, the
I
Supreme
agree,
Court
100%.
is a policy court.
Yeah.
And so there's nothing extraordinary, there's nothing strange with developments in this country. Again, going by our experience, in 2007, 2011, a lot of governorship elections were annulled. The results were annulled. And so, by the courts.
The stakes are, of course, a bit higher when it comes to the presidential level.
They're always very, very high. Always. Because of the interests that are involved.
Yes.
And this time around, again, as I stated earlier, a lot will depend on the evidence.
Yeah,
and issues of law raised.
But based on what you've seen and
for
heard
instance,
so far, I mean, do you expect it to be an epic battle?
It's going to be. Even though the respondents haven't fired their defenses. And until that is done,
that is
one
true.
is not in a position to weigh the type of evidence to expect. So we have only heard from the side of the petition.
Right.
We do hope that as soon as possible, the respondents will fire their responses.
Absolutely.
And then we can look at the weight of evidence that is likely to be adduced by both sides.
Yeah, that's a good point. But let's move slightly away from the evidence. The former president of the Nigerian Bar Association, your colleague Olisa Abakoba, made the point recently that a big problem in all of this is, in his words, INEC at once being culpable and also being a defendant. He suggested that in a situation as we have, where INEC is an active defendant in court, the Commission will obviously want to show that it conducted the election in accordance with the law. He's saying that it would be better if INEC was not a defendant and was simply called to submit evidence about what transpired in the election, rather than having the burden of defending the election that it conducted. Do you agree with his submission?
Well, I'm happy that some of my colleagues are beginning to appreciate some of the points some of us have made earlier, much earlier. I had maintained long before now that the onus of showing that a good election has been conducted should shift to the INEC. And again, this was one of the recommendations of the Ways panel.
That is true.
You said you have conducted a credible election. Prove it. Once there is a genuine petition raising serious questions, the onus should shift to INEC, because it's very difficult, and this is not a Nigerian phenomenon alone, where you expect the respondent who doesn't have the election materials to adduce sufficient evidence to show that the election, or to prove that the election was not conducted substantially in accordance with the law. It should be the other way around. But for now, yes, the point Olisa has just made, INEC would naturally want to go to the tribunal or the courts of appeal to say, we conducted credible elections. However, INEC has also made the point that there were challenges.
Yes, it did say
with respect to the deployment of technology and the conduct of electoral officers. And INEC had also threatened, or INEC had promised Nigeria, that the electoral officers who abused their office or the confidence of Nigeria will be brought to book. And I would have wanted, for instance, some of the petitioners to invoke the provisions of the Electoral Act, because the courts and the tribunals are empowered to recommend the prosecution of those who are proved to have manipulated the elections, to have inflated figures, to have, one way or the other, betrayed the confidence of the electorate. If such evidence is adduced, the tribunal or the court is empowered by the law to recommend the prosecution of anybody who is indicted.
Yeah, but I think the people...
And we have not been doing that.
Yeah, that's a good point. But you know, the people who are going to court are much more interested in simply getting the court to reverse whatever
No, I know
results
that. But where the
in.
law, and it used to happen in the past, where, and I can recall some of the cases in the Second Republic, where the Supreme Court specifically ordered the Inspector General of Police to deal with certain commissioners of police, you know, who took sides in the election, or who did not allow people, police officers, to give evidence and assist the tribunals. And we must also go back to that tradition so that people will know that there will be sanction for impunity.
That's a very good point. But let me ask you this, and let me tap into your considerable legal knowledge. Is it your sense that there are no legal consequences for the failure to use electronic voting, for instance? Because it's been suggested that the Electoral Act allows both manual and electronic processes. So INEC could easily argue that if the electronic process failed, it was perfectly legal and admissible for it to use the manual process. Do you see that as a credible defense at the tribunal?
No, again, I wouldn't want to go into the petitions. Dr. Olisa Agbakoba, SCN, and I were discussing yesterday. And it drew my attention to the recent judgment by the Court of Appeal in the case of Adeleke, you know, and Oyetola in Osun State, where the Court of Appeal simply went back to the voters' register and abandoned the Beaver's report as it were. Now, that is a bit disturbing. So I can also see that being raised, that INEC has the power to switch. And for me, this is an area we have to look at very, very well. You know, we must move. We must move with time. And if there is any takeaway from this election, it is the revolution by the introduction of Beaver's report. A friend was telling me, a former resident electoral commissioner, he was drawing my attention to a state whereby up to 2019, the results that came from a particular area, a riverine area, the result was not less than 150,000, you know. 150,000 people that voted. But this time around, less than 5,000. Because you must be captured by the Beaver's machine. So the old manipulation or writing of results, you know, has been reduced substantially. Even though where you recorded violence and voters were chased from the polling unit, some criminal elements still wrote results. I do hope that a number of them will be exposed at the various election petition tribunals so that we also can learn that it can no longer be business as usual, you know.
But in the circumstances that you were talking about earlier, about it being, about INEC possibly having a credible defense, with the either, manual or electronic processes and having the option, do you see INEC, for instance, working collaboratively with the other respondents and defendants, for example, the APC, Bola Tinubu, in order to win their case? Because now they've been called in as they're a defendant.
Again, as I said earlier, under the current electoral system, the INEC has conducted an election or elections, and the INEC will normally go to the tribunal or the court to say, we conducted a good election and we have declared the results. So usually, the INEC or state electoral commissions usually and normally will go to the tribunal to say, we are defending the elections we conducted. But there are situations where the INEC or the electoral body may be compelled to abandon defending some results. We have had cases where the INEC on its own had taken advantage of Section 65 of the Electoral Act to annul results that were declared under duress. I mean, one of them, I think it was Kano.
Yeah.
Now, if INEC could do that, it may also be possible in certain cases where there was no review, for INEC to go to the tribunal and defend some of the results of the election. Yeah. So that's my own way of looking at it.
Right.
Again, it depends on the evidence produced.
No, absolutely. And as you look back at that election and at the Electoral Act, which enabled what some see as a flawed election, what problems do you now see with the Electoral Act that need to be fixed going forward to make future elections more secure? Will it be, for instance, to find a way to make INEC much more independent, which you touched on earlier, independent of the government of the day than it currently is, and much less burdened with all the things that it has to do to conduct the election?
You know, it interests you, Charles, to know that apart from the late President Yaradua, I set up an electoral reforms panel. The Jonathan administration set up the Ahmed Lemu panel on the violence that greeted the announcement of the presidential election result in 2011. The Buhari administration set up the Ken Nnamani Electoral Reform Panel. And all the panels, the three panels, made profound recommendations to move the country forward and have good elections conducted. For me, we have to go back to those reports, particularly the ways electoral reform panel.
Right.
And for me, that would be the solutions to this problem. Take, for instance, the recommendation on, and it's so important, on the prosecution of electoral offender, because there's no way you are going to stop snatching of ballot boxes, inducement of voters, manipulation of results, declaration of results under duress, instigated by certain criminally, minded politicians. If you do not have an independent body that can prosecute electoral offender, because the belief is that nothing will happen. And that was why I demanded, after the February 25th presidential election, National Assembly election, please, all the people that have been arrested by the police, take them to court. So that those who might want to commit electoral offenses during the governorship and House of Assembly elections will be minded to believe, to know that we could be arrested and persecuted. But nothing like that happened. I think apart from Lagos, where a few guys were charged by the Commissioner of Police in Lagos State. All the other places. In fact, we had a situation where
very briefly
cases were filed deliberately, programmed to fail in Kano. A legislator was accused of culpable homicide, murder. The magistrate that had no jurisdiction order is remand to await the legal advice of the Attorney General. I think a couple of days later, the case emerged in the Federal High Court that has no jurisdiction on murder cases. And the man was freed to contest an election that had been annulled because he had himself declared under duress. In Rivers State, a legislator was caught, I think, with about $498,000, with which he wanted to induce voters. Due to the influence of the state government, he was charged with money laundering. No. It's required to be charged under the Electoral Act.
Well,
again, these cases are programmed to fail. But if you have an independent body saddled with the responsibility to prosecute electoral offenders, the picture will be different. Happily, this time around, the Nigerian Bar Association has entered into an agreement with INEC to have all those who have been arrested prosecuted. The police arrested over 700 electoral offenders.
Pro bono services, I understand.
I'm not quite sure about that. But the MD has assembled, according to the report, not less than 300 lawyers to assist the country in having suspected electoral offenders prosecuted.
Okay.
Which is a good development.
Yes. I want to thank you very much indeed. There was one more thing I had wanted to get to, but unfortunately we ran out of time. But Femi Falana, it's always an absolute delight to have the benefit of your assessment. And Femi Falana is a respected constitutional lawyer, human rights activist, and senior advocate of Nigeria. Thank you very much indeed.
Thank you very much, Chair.